Chapter 13 Bankruptcy Process and Facts. Under Chapter 13, a payment plan for people filing who have regular income is created to be approved by the trustee. The procedure for a Chapter 13 starts in the same way as in a Chapter 7, with a means test and the same credit counseling as in a Chapter 7, and then the filing of the requisite petitions, schedules, financial statement, and other related documents. The next step is that a debt repayment plan is proposed and filed with the court, which is for a period of 3 to 5 years. As a result of the new law, more of these repayment plans will be for 5 years. The gradations of these plans can vary widely depending on the particular circumstances of each case. In rare cases, plans have been approved by the court for as low as 5 cents on the dollar. More common are plans that propose a payment of roughly 1/3 of a filer's total indebtedness, while others can go as high as 70, 80, or even 100% of the total indebtedness. How much debt a Chapter 13 repayment plan will pay out to creditors depends on several factors and can differ from case to case. Payments into the repayment plan are made from disposable income, that is, whatever is left over after necessities such as food, shelter, and so on have been allowed for, while the filer retains their assets. Limitations. Chapter 13 filings are allowed only for persons owing less than $307,675 in unsecured debt and who have less than $922,975 in secured debt. Percentage of consumer filing. There were 449,129 Chapter 13 filings in 2004. This was equal to roughly 29% of the total number of filings in that year. Chapter 13 filings are likely to increase in the wake of the 2005 bankruptcy law change, the mortgage finance crisis, and the current economic downturn, which began in 2008 and which unfortunately continues today. Frequency. A Chapter 13 discharge won't be granted if a person filing has already received a discharge in a Chapter 7, 11, or 12 bankruptcy action within 4 years of the date of filing, or, in the case of a previous Chapter 13 filing, a discharge which was granted 2 years or less before a new filing. Effect on debts. All or a portion of a filer's indebtedness is paid off over a period of time under the repayment plan. With the exception of student loans, support obligations, fines, and certain other priority indebtedness like taxes and wages, all of a filer's other debts will be discharged. A filer's liability to their creditors ends when the repayment plan is successfully completed and the court enters a discharge order. A filer's home will be preserved if a repayment plan is successfully completed and there is no substantial non-exempt equity in the home. However, if a filer's home cannot be preserved in this way, it is possible that it also may be preserved pursuant to other laws, such as the homestead exemption laws or the marital ownership laws. A filer's vehicles will also be preserved if a repayment plan is successfully completed and all the payments made. If this is not done, however, then the vehicles of a filer might be taken by the creditors. Effect on credit. A record of a bankruptcy filing may remain on a filer's credit report for up to 10 years from the date of filing, although, pursuant to the Fair Credit Reporting Act, a Chapter 13 bankruptcy is typically only reported for 7 years from the date of filing. A Chapter 13 filing may also be a better remedy for a filer to try for, since creditors may prefer to see this form of bankruptcy, as the successful completion of a repayment plan under a Chapter 13 filing may pay more debt than would be paid ordinarily under a Chapter 7 filing. In our experience, a filer will be given plenty of opportunity to get new credit within about 1 to 2 years into their filing.